Okay, we have one bill today that we'll be considering, Assembly Bill 177. And this will be presented by two of our committee members. Assemblywoman Seaman and Assemblywoman Shelton. So please proceed whenever you're ready.
Thank you, Mr. Chair. Good afternoon, committee members, fellow committee members. My name is Victoria Seaman, and I have the great honor of representing District 34 in the State Assembly. I am also a member of this committee, but I am here today to present a bill that is both personal and necessary. With me is Assemblywoman Shelton, representing District 10 and Vice Chair of this committee. Both of us have personal experience with some of the wrongs this bill seeks to right, and we thought appropriate to be here together. AB177 has 4 chief goals. First, it ensures that no candidate for this legislature is above the law. Second, it removes the partisanship that has distorted the law. Third, it makes sure that only eligible candidates who actually receive votes in their district become members of the legislature. Fourth, it promotes the spirit behind representative democracy in that an elected representative should be a member of the community he or she is elected to represent. I will now speak on each goal. Perhaps most important of all, AB 177 makes it clear that no legislative candidate is above the law. Every legislative session, we members of the legislature craft, revise, and create law that we expect our fellow Nevadans to follow. We should not allow ourselves to ignore the laws we pass when it is politically convenient. Both the Nevada Constitution and state statutes require elected officials to be qualified electors in the district he or she represents. The problem with current law, however, is not necessarily its lack of appropriate restrictions, but the apparent lack of any remedy when the law is violated. In the last 2 election cycles, 3 different candidates were declared ineligible for office by a district court judge. But the fact that these candidates were ineligible by law this legislature created does not seem to have concerned this legislature. One of the candidates was seated anyway, and the other 2 candidates may have been seated had they won on election day. One of these candidates was my opponent in 2014. She was not eligible to represent District 34. Her declaration of candidacy contained false statements. And despite the time and expense of having a judge rule that she was ineligible for office, had I not won on election day, she could have ended up representing District 34 anyway. That would have been an injustice. The same thing occurred in Assemblywoman Shelton's race. Allowing ineligible candidates to serve is wrong, and it sends the wrong message. When we ignore the laws that apply to us, we tell our fellow Nevadans that we are above the very law we help write. This bill will prevent that injustice, ensure that our laws apply to all Nevadans without exception. Goal 2 is the partisan problems. One of the problems with current law is that it puts the fox in charge of the hen house. How the law is applied depends on the partisan makeup of this body. If Democrats are in charge, they will vote to seat Democrats even if the Democrat at issue was declared ineligible. And I have no reason to think that Republicans would do the same when faced with similar options. Should AB 177 become law, a candidate's eligibility to run for office will no longer be treated as a political football. The law will not change depending on the political affiliate of the candidate or the party in the majority. What it will do is close the loophole of partisanship. Goal 3, only eligible candidates win. This bill will make sure that the only eligible candidate who received the most votes in the election will win. Members of the district will be assured that their representative is not only eligible for the office, but was also the eligible candidate that received the most votes. Rather than turn the process over to the county commission to appoint someone who was never vetted during the campaign, the law will award actual eligible candidates who received votes. Goal 4 is better representation. AB 177 will also promote better representation. The Nevada Constitution requires representatives to come from the districts they represent. Such a requirement recognizes the value in having a representative who shares the concerns of his or her constituents. A representative that comes from the community he or she lives in has a better understanding of the needs of the district. Nobody knows the people and the neighborhoods of a district better than someone who lives there. This is one of the reasons I also increased the residency requirements to run for office. Asking candidates to spend 2 years in Nevada and 6 months, which is an amendment that we're putting forth that we'll talk to you about in a few minutes, in their districts before they run, is not only sensible, it is well within the range of such requirements throughout the 50 states. In fact, even with these added demands, Nevada will still have some of the lowest residency requirements in the nation. With that, I would like to turn the time over to Shelley Shelton, and then over to Daniel Stewart, who will present the bill and go through the changes in the sections of the bill at that time. Thank you.
Okay. Thank you very much. Would you, I think we'll hold the questions until all three of you testify, okay? So Ms. Shelton, Assemblywoman Shelton, go ahead, please.
Thank you, Mr. Chair and members of the committee. Like Victoria had said, I too had run into this same scenario that my opponent did not live in the district. And I just want to let you guys know that this is not just being brought forward because of us. I had so many constituents in my neighborhood that brought this attention to me, and Victoria's bill hits on a lot of things that were problems prior to this bill. First of all, one of the things that in my particular situation, sorry, my husband was he's traveling and he was having some problems, but I just got a text from my daughter saying they're okay. So, okay.
Ms. Shelton, you want to go to Mr. Stewart until you collect yourself a little bit?
Okay.
Would that be all right? Okay. Mr. Stewart, if you'll proceed and identify yourself, please.
Chair Stewart, it's good to be here. For the record, my name is Daniel Stewart. I currently am a policy analyst with the Assembly Leadership Office, so I'm technically an LCB employee. I will attempt to testify in that light. Assemblywoman Seaman asked me to at least go through an overview of some of the sections in there, and quite frankly, I'm sure when you were handed this bill, it looks pretty thick, lots of things to look for. But if you scroll through it, you'll find out a lot of them are relatively minor changes, or they're changes made over and over. And also, as with any election law, anytime we make a change to 293, we have to make a change to the city elections portion as well. It's the same law, it just mimics it. So other than one example, everything I will talk about will be in both halves of the bill. So we don't have to go through both halves unless you have any specific questions about maybe city elections that may be different. First off, I would just like to say that in crafting any of these election statutes, especially this one, there's three constitutional provisions that need to be kept in mind, all in Article 4 of the Constitution. The first one is the members of the Section 3, which is members of the Assembly. This basically sets that they must be qualified electors of their own district, and that they're elected on the Tuesday. So basically election, they're elected on Tuesday. So the election is set by Constitution for how members become elected to this office. The second is Section 5, again saying that they are members, shall be duly qualified electors in their respective counties and districts. that they represent. Third is Section 6, and I anticipate some questions on Section 6. This is the one that basically gives each House, so in this case the Assembly, to judge the qualifications, elections, and returns of its own members. And this one's come in play once somebody is elected. And I bring this up because I think will be a difference between once somebody's actually determined a member and when the legislature takes essentially constitutional responsibility over the qualifications, and then the election process of somebody becoming a member. There's been, it's been our practice, at least in Nevada, that elections have been governed by statute, the time, the manner, early voting, whether or not you have to show identification, so forth. Those are all set in statute, and with the Secretary of State setting appropriate regulations and enforcing elections. So those are the three constitutional issues that I see. There are three sections as trying to craft this bill. And additionally, this bill itself places itself in a significant body of law. The election statutes are already quite long, and so sometimes understanding exactly where it fits, putting it in the broader context. So let me go ahead and start. Section 2 basically declares that if a person is after they file a declaration of candidacy, so it's once they become a candidate, and for help of this committee, anytime I say candidate, I just assume it's somebody that has just filed a declaration of candidacy at that point. And then after that process, they die, they're adjudicated insane or mentally incompetent, or a district court or a court of competent jurisdictions declares them ineligible, their name must not appear on the ballot. So this is essentially rectifying the situation before the ballots are printed. So that fourth Friday in July is the deadline for printing ballots. If before that moment one of these three things happens, the name comes off the ballot. The second portion is what's happened is more common, is that the ruling, we don't get the ruling until after the ballots are printed. Okay, and there's a I guess the teeth of this, or the remedy that the Assemblywoman mentioned, comes in two phases. First, similar to what we have, but broader, there needs to be signs posted at all voting locations that they've been declared ineligible. But in addition, that a vote for, and we'll get to this, that a vote for that candidate will not be counted. Okay. Second, place that same disclaimer on a voting machine, on any electronic voting machine, and then stickers with that same disclaimer on any absentee ballots or paper ballots that might go out, assuming that they haven't already been sent. So that is the preventative portion of this. Where the real remedy comes in is in sections 13 through 16 that I mentioned, that a candidate, and if a candidate dies, they're mentally incompetent or insane, adjudicated, or they're declared ineligible by a court, they cannot, no votes for them will be counted, and we'll have an amendment here that prohibits the issuance of any certificates of election to that individual. So that is really the meat of it. If you want to talk about the bill, is found in sections 2 in conjunction with 13 through 16. But just quickly, I want to go through some of the others. Section 3 basically statutorily changes the term of vacancy to not include death, adjudication, insane or mentally incompetent, or a finding by a court. If it's easier for this court, this panel, I'm just going to refer to all three of those as ineligible candidates. If I say ineligible candidates, we're going to be speaking about those three incidents. That a vacancy will not occur. Now, I want to be careful because it brings in another constitutional issue. If you look at Section 12 of the Constitution, Section 12 of Article 4, vacancy there, but if you look at it, vacancy there refers to actual members of the legislature as opposed to vacancy as in a nomination process or a candidacy for election. So we are not interfering with the constitutional provisions on filling a vacancy, just the vacancy provisions on elections. Section 5 basically lays out the provisions of that we just discussed that will include it. Section 6 same thing. One thing too is in here you'll see throughout on any paper where a candidate is required to file like a declaration of candidacy or a declaration of residency, we've increased it. I believe we agreed now it's a Category E felony.
Right.
Category E felony. For the record, that was Assemblywoman Seaman that said right. If you knowingly and willfully, which is a criminal standard set by criminal law, if you knowingly and willfully make a misstatement on your declaration of candidacy or your declaration of residency or anything similar to that, you will be it will be a Category E felony. Section 7, we've actually had some meetings with the...
Remind us what punishment could be for a Category D felony.
We have changed that in an amendment from a Category D to a Category E felony.
And what's the penalty for
the
that?
record, Daniel Stewart, I don't actually know.
I have my two attorneys. Assemblywoman Seaman, I have my two attorneys that worked on this with me. They may know. They're in Las Vegas. They're sitting up at the dais.
Mr. Powers, do you know offhand?
Thank you, Mr. Chairman. Not offhand, but I could look it up real quickly. But I believe Category E felony is the lowest level of felony. Yeah. And generally, under a Category E felony, the district court is required to impose probation for the violation unless certain conditions exist. So generally, probation is the sentence for a Category E felony.
Okay, thank you.
Mr. Chairman, I just happened to look it up if you'd care.
Mr. Orenshaw.
Thank you. Pursuant to NRS 193.130, Category E felony is a felony. Minimum term of not less than 1 year and a maximum term of not more than 4 years. And it is probationable, fine not more than $5,000. It's 193.130, subparagraph 2E. Mr. Chairman, would it be appropriate to ask a question now? Or
we're going to hold the questions, okay? Okay, Mr. Stewart, proceed, please.
The record, Daniel Stewart. Section 7, Assemblywoman had a few representatives from this Clark County and the City of Las Vegas come and speak to her about Section 7. As it's laid out, it may appear to increase the duties on which they're asked to, a clerk or anyone receiving a declaration of candidacy, a filing clerk. For the record, and we're happy to work with them to get some language on this, all they're going to be asked to do is what they're doing already, which is verify the identifications and the bills and so forth that you have to bring in to show where you live. We're not asking them to conduct any independent investigation on that matter. And we're prepared to work with the cities and counties to get some language that they would like on that issue so that they feel comfortable they're not being asked to do investigations. As for the second part of Section 7 that is related to the investigations, well, if you go to Part 6 of Section 7, this section does discuss actual investigations if there's credible evidence. Somebody receives credible evidence that they don't live in their district or they don't meet any of the qualifications that are set. And again, we're going to make changes on this so that it's clear that it's only the Secretary of State's office or the Attorney General's office that will have the duty or the authority to investigate here. We don't want the county clerks to be out trying to get subpoena power or something to that effect. So again, we've been working with them to get that cleaned up so that they're comfortable with that they don't have any investigative authorities or duties in that regard. I do want to mention that I skipped over, I believe in Section 6, Assemblywoman Seaman mentioned that we initially had 1 year as a residency requirement in the district. That's currently quite low in the 50 states, but we've agreed, I keep saying we, I corrected, Assemblywoman Seaman's agreed to do 6 months in the district as opposed to 1 year. The 2-year requirement for living in the state, there was initially 5 years in the bill that went out. That's been reduced down to 2 years to mimic it with the 2-year requirement that the only residential requirement we have in the Constitution, which is a 2-year requirement for the governor. But again, even that is low. 2 states on the opposite political spectrum, New York and Texas, both require 5 years, just as by way of an example. Section 9 doesn't change much except for it allows the court to award attorney's fees to the prevailing party in this issue. One of the things that we found, or the 2 assemblywomen found during their races and the legal fights that they had is it's hard to have money to fund these legal fights, and to the extent that you can find campaign contributions for them, as an attorney, I'm sad to admit this, but you can burn through $10,000 pretty quickly, even in in-kind donations. So finding law firms or somebody that's willing to fund these, if you can't fund them yourself, can make these challenges prohibited. So this allows the court to, and you see it's May order, that the prevailing party can recover their fees. And that also, again, that's not mandatory. That's just discretionary as we currently have. With that, I'd like to turn to, well, Section 11 adds to the candidate's Bill of Rights essentially the information we discussed, that ineligible candidates can't be elected to office, and any vote cast on behalf of them will not be counted. The big provisions are in 13, 14, and 15. 13 prohibits the counting of any ineligible votes for an eligible candidate during early voting. And I need to be clear, because this is something I discussed with the county clerk already. There's a lot of terms. Counting can be a term of art when you're discussing election law issues. There will be a tabulation, so the number of votes that the ineligible candidate received will not be secret from anyone, but they will be, but they won't be counted in terms of determining the winner. The good example of this is none of these candidates. You can see who wins that, and that. We've actually had a situation recently in the 2014 gubernatorial race where none of these candidates finished first with the most votes, but the second place person was actually the one that moved forward in the ballot. So the number will still be the same, that the counties will still see the tabulation for that person, but they won't be counted in the sense.
That was in the primary, I believe, right?
Primary, yes, the primary. Thank you. Good clarification. And so it would be similar to that effect, that when we're talking about counting, it's just counting in terms of victory. Section 14 makes clear that if you do vote for one ineligible candidate, that doesn't invalidate the rest of your ballot in any way, just like it would if you duly voted for a candidate in one race. Section 15 applies to all the other types of counting, not just early voting, election day, absentee ballots if they're counted on election day, and so forth. Once you get past that, the rest of it is city elections, which is duplicative except for the investigatory section that we discussed where the Secretary of State will have power. That section's not in the city elections, again, to get to our intent that only the Secretary of State and the Attorney General can carry out these investigations. There's been some proposed amendments in addition to so here are some of the proposed amendments I've seen. Some of them have been posted already. Others I've discussed already. We'll amend Section 2 to remove the language providing the county clerk determines that there is not time. It will basically say that if the county clerk has already printed the ballots. So my understanding is it will use the deadline that's already set by statute, which is the fourth Friday in July. And also to add that it will require the county clerk to remove the name from any electronic ballots if there's time. Again, Section 3.1 makes clear that if a vacancy occurs, no party may nominate a replacement to fill the vacancy. Now remember, in Section 3, there was a carve-out of what counts as a vacancy, that death, incompetency or ineligibility does not count as a vacancy. The other amendment was the Category E felony. We've talked about the two residency requirements that have been dropped down, and then there was a mistake in one of the section 29 didn't have the knowingly or willfully language in there, and we made sure and put that in. One of the things, additional amendments that may be in, I've talked about, is making sure that it's the Secretary of State and the Attorney General that has the investigatory authority. We also need to, if this bill passes currently, we'll need to get rid of NRS 293-166, which is a special provision for filling vacancies for a nomination when you have multi-county districts. I think we'd like to add a definition of an eligible candidate, because that word is used throughout, that include the three categories we mentioned. I think we covered that one. Any postings of the election results will include the disclaimer on there that an eligible candidate can't win, and then also making explicit that an eligible candidate can't receive a certificate of election. I feel like I rushed through that. I'm sure you probably didn't feel like I rushed through that, but I'm happy to take any questions at this time. Thank you.
Before we start questions, let's Ms. Sheldon finish her testimony.
Thank you, Mr. Chair. So back to I just wanted to give you my viewpoint and my experiences as far as what happened during the election. And I think Victoria's bill is so important because it hits on a lot of the aspects that have been overlooked throughout the years. Because in our case, we were able to go back and find case law and see that this type of stuff had been happening before. And I think in Victoria's bill, it is addressing everything. I wanted to just point out a few things just so you have some understanding. On the first part of it, on section 1, on page 3, it's talking about, on number 2, it says, place a notice on each mechanical recording device informing a voter who uses the device. And I want you to just know how important that is, because they put the signs up, and they did that in both of our cases, but people are either, they're busy. They're walking past the signs. They're not paying attention to the signs, and they really don't understand what the signs are there, or even noticing the signs. And I didn't realize how important that was until we actually were able to talk to some of the people that were going in, and they had no idea. Even though it'd been in the papers, even though there was the signs posted up, most of the people had no idea. So I want you just to know how important that is, that the voter be aware, and that the signs be not only posted but also on the devices. The second place is if you turn over to page 4, and again, I don't want to go over the whole bill. I just want to clarify and give you a little viewpoint as far as the vacancy, and that they've added in here by a finding by a court of competent jurisdiction, because that wasn't in there before. So we ran into the situation of, if there's a vacancy, who's going to be able to fill that vacancy? Is it going to go to the county commissioners? Is it going to be something that the assembly does? There was confusion within that. This clarifies that. And then another quick few little things I wanted to point out is conducting the investigation. I personally felt like the hands were tied for not only the Department of Elections, but also the Secretary of State, because they kept telling me, you have to go to court, or a judge has to decide. I think this allows them to have the ability to pursue this in a more efficient manner. And then if you turn over to page 12, if there's not time to remove the person's name, which was the case in both Victoria and I's election. No vote cast for the person may be counted. I can't tell you enough how it infuriates the voters that they voted for somebody and then find out that they weren't able, that was an ineligible candidate. And I think that's the important thing to take away from here, because the voters spoke this time. They were both able to be aware that before the election, before they cast their ballot, they were informed, as well as we could inform them at the time, of the ineligible candidates. And I think their vote spoke loudly as Victoria and I sit here before you. Thank you, Mr. Chair.
Thank you very much. I think we have
Mr. Chair,
go ahead.
can I ask that my two attorneys in Las Vegas speak and join us for questions, because they were actually have a lot of knowledge about this bill and why it's come about, because they represented me.
Certainly, Ms. Seaman.